Good morning, you're Mark Garcia.
Yes, ma'am.
And Mr. Garcia, calls number 25 DCCR 0120. You were previously in court. You entered a plea of guilty to theft of material, aluminum, bronze, copper, or brass, a state jail felony, and that was a cap of 16 months in the state jail prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have to.
I do, Judge. Are there any additions or corrections?
Yes.
Explanations?
Yes, there is one issue that we would like to address regarding his statement.
Okay,
And Judge, that was in regards to his description of what happened as far as when he talks about them not stealing the copper. I think that was more of an issue of course, him not admitting that they were caught in the act. And this was something that was after the fact he was stealing the truck. He understands, how that may have sounded the way he expressed himself, and he totally takes responsibility for it.
so Mr. Garcia, you said specifically in quotes, we did not steal anything from there.
We didn't, but we were caught there. We shouldn't have been there in the first place. I accept responsibility for what we were doing.
Well, what were you doing? What are you accepting
Well,
responsibility for?
we showed up to look at the site. We were supposed to check it out. And that's when the cops showed up. I wasn't even in the, I was there, I was in the truck when the cops pulled up, but I thought we were there on a job. So thought we were supposed to be working, we were supposed to land, but we hadn't yet. But I accept responsibility for what we're there to do, you know what I mean?
I don't know what you mean. That's why I'm asking you, because you're saying you were there in absolutely legit reason. And there was material in the back of your, here's the thing. Now's the time not to gloss over it, okay? Either you did it or you didn't do it.
Yes, ma'am, I did. That's why, but
that's not what you're saying. You're saying you went there to do a job and the cops pulled up and y'all just got in trouble and you don't know why.
For 10 minutes. I mean, I don't know how else to put it in words. I did what I'm accused me of doing. I don't know how else to word it. She asked me to describe the situation. I did.
You said we did not steal anything from there. So did you or did you not steal?
I did.
Okay. So that's not what you just told me.
I don't know how else to word it. I hadn't gone in yet. We hadn't, but I don't know what to say.
But the stuff was in, you had cut copper, a reciprocating saw, drills and tools in the immediate area, in addition to multiple bundles of copper in the back of the truck. So how, I don't still understand. Did you steal the copper or not?
Yes, ma'am.
So now let's go to your criminal history and the fact that this isn't your first time to do this. You've got 1, 2, 3, 4, 5 prior felony convictions. You've received the max of 2 years state jail on 2 of them. 1, possession of a controlled substance and fraudulent use or possession of identifying information. You've received a 1-year state jail on theft of material. You've received a 2-year term on possession of a controlled substance. What all that means to me is that the deal that you received going on count 1 only, you could have been looking at 2 to 10 instead of just a state jail. And I don't agree. I think after seeing this, Ms. Malfino, is there something else that you either did or didn't know that would go into the state's position on that offer?
Judge, only that in my review of those priors, there were two state jails that did not need to be sequential, so I would agree that it could be a 3rd degree. I totally understand the court's confusion with something less than is what the 2 years that he has already received, and if we need to revisit that under a 3rd degree.
There's no facts or issue. Is there any, I mean, I guess any underlying facts or issues with the case that
Not particularly, Judge. I mean, I know some of the people that run the AT&T, and I know this is a very menacing type of offense that then leads everyone else's bill to increase because we're all paying for what they're doing, but nothing particular because of this offense, Judge.
Okay, then I'm not going to accept that agreement. It doesn't make any sense to get rewarded for continuing bad behavior if there's not some underlying other issue.
And Judge, just to kind of point out there, mitigating circumstances for us, Mr. Garcia, he was dealing with a drug habit. That even is why he's in custody right now from testing positive when he came into court. He has been struggling with that, but he has done some things or to try to move himself from the surroundings he was in. Even while the case was pending.
I appreciate all that, but there doesn't seem any reason for me at all to agree to a 16-month sentence when this is his 6th felony offense, and it's the same type of offense. And the last time he was enhanced, or it was at least a 2-year in prison, in TDC, not state jail. He's looking at 2 to 10 if he went to a jury, and I don't think 16 months is appropriate at all. I don't think that's what a jury in our community would think was appropriate for someone who continues to, y'all go talk about it if you want to. I can reset it and you guys can kind of renegotiate and look at it and let me know. But at this point, I'm going to reject that offer.
Okay.
Good morning. Are you Eric Segrist?
Yes, ma'am.
And Mr. Segrist is charged in cause number 25, DCCR 1836 with burglary of a habitation. Mr. Lewis has filed a motion asking that I reduce the bond, which is currently set at $50,000. Mr. Lewis, you may proceed. Mr. Segrist, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Go ahead, Mr. Lewis.
Mr. Seacrest, will you state your full name for the record?
Eric Martin Segrist Jr.
Okay, at the time that you were arrested, were you employed at that time?
I actually I had a job interview for Walmart the next day and I missed it.
But at that time, you weren't working?
No, sir.
Okay.
No, sir.
Up until the time that you were arrested, were you able to have any money saved or anything like that that you could use towards your bond?
No, sir. My sister was planning on helping me out.
Okay, so any help would come from your family?
My family, yes, sir.
Okay, now the employment opportunity that you did speak of, is that still available to you?
Yeah, as soon as I go home. Like she actually asked about me yesterday morning.
Okay.
And I have a neighbor in my neighborhood.
Mhm.
And she has like a bunch of overgrown trees and she was asking my sister if I could come over there and clear out all the stuff, and she was gonna pay me to help bond out.
And if you're able to make bond, where would you be living?
At 6161 House Street in Groves, Texas.
Okay, now, is that the same residence as the complainant in this case?
No. So that's my sister's house.
Okay, so you will be able to handle any type of bond conditions, for example, like no contact with the victim, things of that nature?
Absolutely, and the job is walking distance from my house. Like it'll take me 20 minutes to walk there, my house. And I just bought a brand new bicycle, so I could ride my bike straight to Walmart to go to work.
Okay, now, as far as the bond amount, it's currently set at 50,000. About how much do you think your family could afford to try to help bond you out?
Well, I'd say, because I have another bond that's 10,000, and so probably around that area, so she can get a better deal with the bondsman, like around 10,000.
So you're asking for a bond, you said it's 10,000 on this case, but ultimately you would have a bond obligation of approximately $20,000.
Yes, sir.
Pass
What's
the
the
window.
other bond for?
It's for an assault case, I believe, Judge.
The misdemeanor.
Yes,
assault.
misdemeanor assault case.
Any questions?
No questions, Mr. Judge.
Any other witnesses?
Oh, no, Judge.
All right, Mr. Smith, what is the state's position?
Judge, this was a case where he broke into this house sliced his arm very badly on the window, trying to break through the window. Assaulted the victim in the case, stole her phone and ran away after the police had been called. Um, they were able to find him because they used to track my iPhone. It's family violence. They were living together at the time. We have had contact with her. She came in and talked to me last week, or before last on this, so we would be opposed to a bond eviction.
And just for the record, I'm taking judicial notice of the court's file. It does include the probable cause affidavit, and so I have reviewed that as well. Anything else, Mr. Lewis?
Well, Judge, this is the one that we, of course, reset from recently when the state was looking to hear from the complainant in this matter. And I think, like Mr. Smith said, they did have a chance to talk to her. And even from my understanding from that conversation of what we're dealing with is a situation where it's still kind of shaky as far as factually of what went on between him and her that evening. It is something that he definitely wants to pursue. I'm not just going to say a trial, but to pursue this matter further as far as trying to get it resolved. He does have plans to hire his own attorney, who is Mr. Parker. He's gone now, but that's initially who the family's going to try to help hire for him. So they're looking to bond him out and hire his own attorney as they proceed with this matter. We're just asking for him to have that opportunity. That way he can get back to work and help pay for that on his own and not be situated any burden obligation on his family moving forward.
Okay, at this time, taking into consideration the factors in our 17.15, I am going to find that it is not in the best interest to grant the motion to reduce the bond. I'm going to deny that. The underlying facts, the testimony today. And so what we'll do is get it set as quickly as possible. If the family hires Mr. Parker, great. If not, then Mr. Lewis obviously will remain as your attorney and move forward with going through discovery, and we'll get it set for an announcement and move forward as however you guys plan to at that time.
Okay.
Okay,
Thank
go
you.
back with the bailiff. Good morning. Are you Kenneth Bartol?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Your Honor.
I am going to first also, I think we've probably done it, but just to make it clear, I'll take judicial notice of the court's file. In each of the cases, Mr. Barthol was evaluated by Dr. Kahan for competency to stand trial. And we received an evaluation and report back on November 3rd of 2025. The finding in that is that Mr. Barthol was competent to stand trial. Is there any other evidence with regard to competency today?
No, Your Honor. No, Your Honor.
All right, then based on that, I will find that Mr. Barthol is competent to stand trial and proceed. So Mr. Barthol, in cause number 25, DCCR 1207, you're charged with the third-degree felony offense of obstruction or retaliation from July 19th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Mhm.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25, DCCR. That's a state jail. Are we going on count one only in the state jail case?
So is that?
1752.
Yes, Your Honor.
Give me just a minute. In 25 DCCR 1752, the state has elected to proceed on count one only. It alleges you committed the state jail felony offense of possession of a controlled substance from January 11th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And then lastly, we have cause number 25 DCCR 0878. And in that case, you're charged with a third-degree felony offense of obstruction or retaliation from May 24th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In all three cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
Objection.
It's admitted. Is there any, again, there's no other evidence about competency. All right, Mr. Barthol, I'm going to find in all three of your cases that you entered your pleas of guilty freely and voluntarily. Find, again, you're mentally competent. You understand the nature and the consequences of those pleas. In cause number 25, DCCR 1752, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 1207, also find that you enter your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 25, DCCR 0878, also find that you entered your plea freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to go back real quick because I think I failed to mention, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Okay. These cases will run concurrently, which means together at the same time. I will sign dismissals as part of this agreement in cause numbers 25 DCCR 1206 and 25 DCCR 1208. I'm handing you in each of your cases the trial court certifications. That shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.